May I please your lordships?
Yes.
Yes. Now, my lord, am I audible, my lords?
Yes, yes.
Yeah, there are only 2-3 issues. That, my lord, the matter was not fully heard. And the MSME, since the proceedings were recorded, and that will amount to contempt of court, therefore we take up this issue to refer the matter to the Chief Justice. Thereafter, the matter will be further heard. And then a judgment came to be delivered. So the case was one, going by the records, that it was not fully argued. Therefore, I have now an opportunity to reply to the contention rejoinder, an opportunity to reply to the contentions of the respondent bank. And that is only, therefore, the fundamental principle is that a party should have a full fair trial by the fact-finding, at the hands of the fact-finding tribunal, and there are an equally right for appeal. So, if the right of a fact-finding, if a proper trial has not been allowed to be conducted, then that defect cannot be cured by a appeal where the principles of natural justice is fully observed. And then the principle is there's directly on the judgment on this case at the hands of the Supreme Court in the ICICI Bank versus Institute of Chartered Accountants versus Enguta, where the Supreme Court has referred to the quoted Lord Magari. So therefore, that is one aspect. Second aspect is, my lord, the primary plea that my contentions are barred by the doctrine of precedent. And your lordship's judgment in the earlier case, in the case of Krishna Umar, stand as a mark.
Just one minute, because last time we had put a query to you that this decision of the division bench and Pronit case, that at least the division bench, since it was the same composition, we know the facts very well also. That was a case where this objection was not raised at the inception. This case, the objection is raised at the beginning. The learned signature says that objection should be raised before the account is made NPA. That is not the law either by the Supreme Court or by the division bench. Division bench says that if you have an afterthought after 2-3 rounds of litigation, then you are precluded. But the MSME is right, as recognized under Pronit, continues. It can't be nullified just because they did not raise it. They raised it here, which we have seen. That's what we put it to you last time.
The account is declared as NPA. It's well settled that once SARFAESI Act comes into play, it overrides MSME Act because there is a Supreme Court decision on that also. Now the question is, what is the remedy as far as the MSME is concerned prior to the NPA being brought in? In this case, there are records on record that this certificate by MSME was communicated. I'll take my notes to the records, was communicated. There are at least 4 communications thereafter saying that they promised to give a proposal. It was not given. There are at least 4 communications on record which are brought on record, asking them to give the records, to give the proposal.
Now just turn to page 65, which is a notice issued by you in the beginning.
The bill number 484 or
First one.
481.
That is under 13.2.
You want to subject the 13 to notice?
Yes, page 65. Or page what? There are 2 pages. First is 103 and one is 102. Exhibit P7.
P7.
Now this
P7 is
13.2.
P6 is the 13 to notice.
Yes.
P7 there is a appeal number 484.
What is the date?
is the 13th notice is dated
16th August 2000.
18/10/23. That is 13th notice. That is exhibit P6 in bill 484. That's a bill 481. 481.
Our reply.
P7 in 481, P7 at page 60, page 102 in fact.
So now this is one. This is of 16th August 2013.
That is true.
Then you go to the reply, which is thereafter in October.
Yes.
So this is not some afterthought. This has come immediately. It
Yes.
was missing in the other cases. What we are pointing out that this is here. There is in the paragraph 4. They say that they are whatever they want to say in the petition. They have said it
Yes.
here.
Yes.
Now your response thereafter is
On page 112.
there. You don't say you were given an offer earlier. You say that that's it. We confirm it.
The reason
Your theory that they were given offer, where is it in the correspondence?
but it is there. I have produced the correspondence.
Where is it here?
Yes. My lord. In the petition also.
No, what we are saying is in this letter, the next letter,
It says
does
that
not-
they are given opportunities.
where is it?
I mean, just not so many words say that we are given the reply, but we have
Therefore,
produced
what
it
you
on
are saying
record.
is something else. The fact that the MSME enjoys particular protective status is even acknowledged by the Supreme Court.
Yes.
Thereafter, the relief is not given to the party on the ground that you can't have a belated thought about it,
Yes.
which is a principle which we followed in the other days.
Yes.
But if a party refers to it immediately, is there a decision on that point?
No, I'll come to that.
That is why we were telling you that this requires some sort of hearing.
No, I understand.
This is not directly covered by that
No,
decision.
there are two writ appeals. One is 481 and the other 484. So 484 is filed by a company.
Yes.
Company whose exposure to the bank is more than 36 lakh crores. So straight away anything about 25 crores. Under the RBI circular, they go out of the scheme.
Yes.
So the writ appeal 484 cannot be considered under the scheme at all. Because this the total loan exposure is more than 25 crores. 25 crores is upper limit as per RBI circular.
Now, this company also write to you that they are MSME.
They claim they are MSME, they don't call they are not MSME.
What was your response to that letter?
Response clearly saying that more than 25 crores, you don't come under the scheme.
Where is that?
That's
In the second
if I allowed to that RBI circular itself.
No. Once they invoke MSME status, was there your response to that you are not an MSME because you are
No,
above?
we are not saying that not MSME. Even if they are MSME, this scheme applies to only loans up to 25 crores.
Yes, what we are asking you, once they invoke the status of MSME as a reply to your notice, was that your response is what we are asking you?
No, that is the response because there is no quarrel that they are MSME. We no quarrel. But even MSMEs to come under the scheme for special protection of special dispensation of MSMEs, it is only up to loans up to 25 crores.
Is that your response? Where is
Not
that?
on that, not under 13(3)(a). Not under that.
Once an account is declared NPA, A for individual as well as the company, both have invoked rightly or wrongly status of MSME.
Yes.
Was that your response that A, we have given you sufficient opportunity, you did not avail, therefore you are not entitled to protection for an individual, and for the company to say that you fall above 25 crores, therefore you are not entitled. Is that your response?
No, that is not the specifically response. We say that you are not covered under the scheme. That is our general reply. Because under the scheme,
All that we are saying, it is not, does not warrant a summary disposal as has been done by the impugn order, because these facts were not there in the other matter.
no, that I understand. But even on the facts of this case, when clearly it's facing, the company does not come with the scheme at all. If the claim as MSME, to claim that scheme, you have to be within 25 crores.
All
That
right,
is how.
keep it immediately after you take it. requires to be heard. Council will have to write a judgment here. Because ultimate object of pronate is to give protection to MSMEs, not to take it away by law. So protection of the cases we have not extended, but does not mean that we start taking away.
My submission is protection to the limit approved by pen as designed by RBI.
Where is your defense is what we are asking.
You know, not in terms of reply, but all the reports are there because this is not the first round. You got the DRT where this detailed they withdrew the DRT matter came here. They've come here once before without claiming that they're MSME. So this is not as if this is the 13.3A is not the last or first letter which you have sent them.
Once if MSME defense is raised, the matter can go on different track altogether. It need not come under this act. If it is wrongly declared as NPA, and SARFAESI Act itself does not apply. Therefore, we want to know whether once somebody invokes, bank is also equally responsible to inform them that A, you are not entitled to MSME protection, or that we had offered you but you have failed, therefore we are going else. Neither of them responses are there.
Bank in this
You are just stuck to your response of
in this case, what bank did was there is an obligation to classify under SMA and inform the party that you have been classified under SMA. They came to us. They said we'll submit a proposal.
All right, we are not closing the issue. We are saying that this cannot be just dismissed on the ground of pronate and the decision of the bench.
The facts is slightly
This
different.
case will have to be seen or no.
I do concede the facts is slightly different with Krishna Kumar and
Keep
pronate.
it after the reopening. Next week after reopening. Then counsel for the parties on the issue of protection of MSME to the appellant's original petitioner. Counsel for the petitioner contends that the decision of Supreme Court in pronate of the division by V.K. Krishna Kumar will have to be looked at as the facts of the present case are different. Post on 22nd May, first week after reopening, we'll place it. Yes, keep it up first week after.
Interim protection to continue.
That is
Without
a statement.
interim.
No, now because we have taken possession of all the properties except two residential houses. Everything is already in our possession. The houses will not do pending. The others are already in our possession.
All right.
Huh?
Yes, your
That
Lordship.
may not be, that may be record or may not be interim.
So far we are not recorded. Yes.
The first appellant, Your Lordship, is the nominee under Exhibit T1 policy